Hi and welcome back to the channel. Today I'm talking about neighbouring disputes that involve trees such as overhanging branches, encroaching roots, or creeping ivy and things of that nature. But first of all, if you're just joining our community and you've got your own questions and comments, don't forget to like, comment, subscribe and hit the bell icon so you don't miss out on future videos. And just a reminder, I'm going to get going on my views and analysis vlogs over on Black Belt Secrets, where I'm going to analyse your situations and give you my views. Not legal advice, of course, but jump over there and let me know what your situations are. So trees, first and foremost, a tree is considered to be anything that looks like a tree. But first of all, one overarching warning that I will give you is in respect of tree preservation orders or tree protection orders. This, as it sounds, is an order made by the local authority intended to protect the tree because it's seen to give a significant benefit or amenity to the area. It can apply to any kind of tree or any number of trees in a given area, and it can be on public and private land. A tree preservation order makes it a criminal offence to do any of the following to that particular tree without written consent from the local authority. They include cutting down, topping, lopping, uprooting, willful damage or willful destruction. And that includes whether you permit anyone else to do so. So it wouldn't be a defence to say, have a tree surgeon come out and do it for you and then claim that it wasn't you that did it. You still need the written permission from the local authority. Furthermore, even if you do get written permission from the local authority, the work has to be carried out to a certain standard, which usually means you are much safer to get a tree surgeon out to do the work rather than carry it out yourself. Although most local authorities will give you some guidance as to how to do that, my advice would be to speak to a specialist. So one of the first questions asked is whether there are any limitations as to what you're allowed to plant in your garden. Now, with the exceptions of things such as Japanese knotweed, there are generally no restrictions about what you can plant in your garden, although it's worth bearing in mind that if you plant a tree that is going to get very large and it's right next to a drain and the roots are likely to grow into that drain and cause damage, this may very well lead to a nuisance claim, so it's probably better to avoid that sort of scenario. Also, with such a large tree growing near the boundary, if it has branches that are overhanging and let's say they get damaged and fall and damage your neighbour's property or your neighbour's car, again, you may well face a civil liability claim for damage that was reasonably foreseeable that you didn't take steps to prevent. So whilst it's nice to have tall trees on the boundary of your garden to create that sort of shielding effect, it is worth making sure that you keep those trees neat and tidy. Speaking of tall trees, one common problem is when a tree grows very tall and blocks out your light. This is covered by the Right of Light Act 1959, which provides that if your property has enjoyed continuous light for the last 20 years, it is entitled to continue receiving it. This might be particularly relevant with very fast growing trees. Very often I see a line of trees that have been planted with the intent of them growing tall to create this barrier. The problem there is they continue getting taller and they can be very expensive to cut. So if they keep getting taller and block out all of your light, effectively creating a big shield preventing light entering your garden, and you want to continue receiving it, you may be able to apply to the court for an order either to have the trees reduced in height or to be taken down. But it's also worth considering that some trees will come within the high hedges, and it may well be that an argument is better placed there than under the right of light. So let's say now your neighbour's got this very tall tree and the branches are very quickly spiralling their way into your garden. A common question is whether or not you can cut off those branches. Now, with the caveat that I said at the outset, with a tree protection order or preservation order, you would need, or your neighbour would need, permission from the local authority to even trim those branches. But let's say that's not the case. You are permitted to cut those branches off. It's considered to be abating a nuisance, and you don't need your neighbour's permission to do it. Although strictly speaking, you should be offering those branches back to your neighbour rather than keeping them for yourself. This, in the strictest sense, could be considered theft. And it's also worth remembering that you cannot just help yourself to fruit that is overhanging just because it's overhanging your garden, or whether it's fallen off. You cannot just help yourself to that fruit. It still belongs to your neighbour. It's also a bit of a myth that you can cut these branches off and just throw them back over the hedge. That's not permitted either. But in reality, if you were to approach your neighbour and ask your neighbour to cut the branches themselves and dispose of them themselves, they may well be willing to do that. I always recommend a civil and reasonable approach, but in the end, if your neighbour is simply refusing to cut those branches off, you can do that, but then you must offer them back to the neighbour before you dispose of them. And if you've cut them off and your neighbour refuses to have anything to do with them, then you must dispose of them yourself. It's also worth remembering that if you cut the tree very badly and cause damage to the tree, this could well amount to criminal damage, and there might well be consequences for that as well. Now, it might well be that your neighbour doesn't like the look of the tree afterwards because it sort of stops at the boundary line, but there is no legal recourse for that because you have abated what would be a nuisance by this tree overgrowing your boundary, and you're entitled to cut it off. In most of these cases, I would recommend that you still get a tree surgeon to come out because they are likely to do a better job of cutting the tree than any of us would. Just a quick word on fruit. If the tree is on public or common land, that will usually be okay, but please see my other video, which I'll link in a card now, about the right to roam and the right to forage. But again, just a reminder, if your neighbour has got a beautiful fruit tree and lots of fruit is hanging and dropping onto your garden, you cannot just consume that yourself. You still need permission from your neighbour. So how does this affect leaves in the autumn? If you've got lots of trees along a boundary and they all shed their leaves in autumn, then your garden becomes full of leaves. The common question is whether or not you can insist that your neighbour comes around to clear up the leaves. And again, the short answer with this is no, there's no obligation on your neighbour to come round and sweep up those leaves. But I would say that there might be an exception. Let's say if there's a drain nearby and those leaves are continually blocking this drain, whether it's your drain or a public or shared drain, then if you were to formally put your neighbour on notice that this is happening and it's causing a lot of expense year on year, then it may well amount to a nuisance. But I would always urge caution in even starting or threatening legal proceedings against your neighbour, because it may be necessary later on to declare that there's been a legal dispute with a neighbour. Otherwise, when you come to sell the property and fail to declare it, there may be further repercussions down the line that you hadn't thought about. Generally speaking, again, I say come back to being civil, being neighbourly, and go around and discuss it nicely, openly with your neighbour and say, this is a continuous problem. What can we do about it? Maybe we can share the costs with it. Maybe we can share the responsibilities of doing it ourselves. And again, just being reasonable goes a very long way. So let's take this underground, so to speak. Let's say the roots are now causing a problem because the roots are encroaching on your property. Again, same caveat applies with tree protection orders or tree preservation orders. You cannot touch the roots without written consent of the local authority. But that aside, the same principles apply to the roots as per the branches. You can cut them off if they are encroaching into your property and they're likely to cause damage. But with the roots, I would urge a bit more caution, because if you cut sufficient roots off that it causes significant damage to the tree, let's say the tree dies or collapses or something else, you may then be incurring a liability if you've caused sufficient damage to it. On the flip side, the same applies if your neighbour's roots are growing into a drain and it was reasonably foreseeable, your neighbour is on notice of it, your neighbour then becomes aware and on notice of foreseeable damage to the drain. There may well be a liability there if your neighbour refuses to act to prevent the spread of the roots. And in cases that I've personally dealt with, I've known the tree surgeon advise the tree owner to take the tree down because of the potential liability of damage to the drain, which of course, if the damage to the drain is such that the whole area needs digging up and the drain replacing, that will be a significant cost which may well fall on the tree owner. So now let's think about tree ownership and tree responsibility. Now, the responsibility generally will go hand in hand with the owner of that tree. The owner of a tree, just like any other bush or shrub, is generally the person that owns the land out of which the said tree is growing. This is an important consideration when you maybe don't know who owns the tree. You'll need to look to who owns the land. So a common question is whether the local authority is responsible for trees along the highway. Generally speaking, they are not, because the local authority doesn't necessarily own the land that is along the highway. The local authority is going to be responsible for trees that are growing on land that it owns. So in that scenario, it might be worth a quick letter to the local authority to determine whether they own or have any interest in that particular area of land. Leading on from this, lots of people say that they didn't plant the tree, so they shouldn't be responsible for it. But the simple answer there is if you own the land, then you own the tree, for the same reasons I've just described. So how about if you're just fed up of the tree and you want to cut it down? My first warning, of course, is make sure it doesn't have a tree protection order on it. The second warning is to check for bats or birds, because the Wildlife and Countryside Act 1981 prohibits you from cutting down a tree that has a bird nest in situ or in progress, or a bat's nest in situ or in progress. But again, I would recommend bringing in a specialist to determine exactly what species it is to make sure you're not doing anything wrong. So finally, a word on invasive and destructive plants such as creepers and knotweed. Obviously, the more damage that is caused, the more invasive the species and the more notice that the owner has been given, the more likely a nuisance claim is going to succeed. A fairly recent case that illustrates this quite well was where a claimant tried to sell a property only to find that no lender would lend against it because there was over 600 square meters of Japanese knotweed on a nearby railway embankment. Network Rail were warned of the danger posed by this plant some years beforehand, but nonetheless allowed it to encroach onto the claimant's property. The claim was in private nuisance for unreasonable interference with the claimant's property, and the claim sought an injunction for removal and treatment of the plant and damages. The claimant succeeded at first instance and was awarded £15,000, but that decision was appealed. The Court of Appeal then clarified that the tort of nuisance was not intended to protect the value of a property, more the use and enjoyment of the land. So in essence, the first part of the appeal succeeded because it was pure economic loss. In other words, the property went down in value because of the Japanese knotweed. However, the Court of Appeal went on to say that because there was actual knowledge of the presence of Japanese knotweed and the risk that it caused to the amenity of the property, the damages were suitable. Because the knowledge of its existence, the risk that it would interfere, and then the following failure to do anything about it to prevent that interference was sufficient to give rise to a cause of action in those circumstances. So you can see from that one example that many questions do not have a yes-no answer. They can take many years to go through court, and of course many tens of thousands of pounds. So as always, I urge you all to be vigilant, get surveyors to check the property, the surrounding areas for any dangers that you may not foresee down the line. It's much more difficult to deal with them later than it is to be prepared for them up front. So I hope you found this overview useful, but please do seek formal legal advice if you have any pending complaint or any pending action or any current action. Do not rely on this video or anything else you read or see online. Seek formal advice first. In the meantime, don't forget to subscribe. Thanks for watching, and I'll see you next time.